On the matter of the estate of John Reed and Harold Reed.
My video.
Have Ms. Chavez representing Corey Reed on the line. We have Ms. Schrader on the line representing Christopher, and I'm assuming Samuel Reed. And then I'm not sure, it looks like there may be other people that are joining us on Zoom. Just want to recognize them. If maybe council could help me with who's here.
I saw Corey Reed on Zoom there a second ago. I'm not sure where oh, there he is. He's
Okay.
on the SCJ public iPad. My client, Christopher Reed, will not be present. He'll be appearing through counsel.
Okay, very good. Welcome to Mr. Reed. All right, so we're here. There was a petition to admit the January 2025 will to probate, and I noticed that there was the most recent filing, where are my notes here? It gave me the impression that Ms. Chavez and her client had responded, I think just recently, maybe late last week, and then Ms. Schrader.
At the beginning of the hearing, the court discussed the estate case of John Reed and Harold Reed. The judge opened the meeting and confirmed that the hearing was being recorded. Several lawyers joined the meeting through Zoom to represent different members of the Reed family. Ms. Chavez appeared as the attorney for Corey Reed. Another lawyer, Ms. Schrader, joined the meeting to represent Christopher Reed and possibly Samuel Reed as well. The judge also noticed that other individuals were present on the Zoom call and wanted to identify them properly. Corey Reed briefly appeared on the screen using a public iPad. However, Christopher Reed himself was not present in the meeting. His lawyer explained that Christopher Reed would appear only through legal representation. The judge welcomed Corey Reed and confirmed that the court was ready to begin the hearing. This moment marked the formal start of the legal discussion about the estate.
My assumption was that she and her client would probably want to respond. So maybe you all could just share your thoughts with me on that. Maybe Ms. Chavez or Ms. Schrader, you can go. Whoever wants to go first. I'm fine hearing from either.
If I might jump in very briefly, Your Honor, that is accurate. I would like an opportunity to respond to Ms. Chavez's recent filings. I think there's a couple of items that the parties want to put on the record today, but my ultimate proposal would be to set this to a trial setting docket. I think we're going to need a longer motion hearing, so we may want to special set this for argument on the petition and the objection. So there's just a couple of items I think we need to go over today other than the trial setting.
Okay, thanks. Ms. Chavez?
Thank you, Your Honor. Yes, Ms. Schrader and I had the opportunity to confer a little bit earlier today, and I agree. I want her to have adequate time to respond to our objections and responses, so I have no issue with setting this over. I believe we discussed about a month for a trial setting docket to have sufficient time for us to present argument to the court, and I do have an additional record and some requests for the court to hear whenever you are ready for that.
Okay, so let me just clarify. There's a reference to about a month out. Is that for the trial setting docket about a month out, or putting this onto a trial setting docket fairly quickly and looking for a set in about a month?
That's the proposal, Your Honor. So the next available trial setting docket, and then we can select a date on that docket about a month out.
Okay, and Madam Clerk, can you help me remember the date for its universal trial setting docket?
Wednesday, 9 a.m.
It's on Wednesdays.
Great, Wednesday, 9 a.m. Thank you, appreciate that. All right, today being the 24th, we would then probably be looking at October 1st at 9 a.m. Is that a date that would work well for both counsel?
That works for me, Your Honor.
I'm available as well.
Okay, so we'll set it for that date. That's a Zoom or Zoom only docket. So we'll set it to that date, and so we can choose a date and time to have a full hearing and get a time estimate of what the parties think it will take to hear that, and we can get it set and get it heard. And then it sounds like there are some additional items the parties wanted to address. Or no?
Yes, Your Honor, I do have some additional items to address.
Go ahead, please, Ms. Chavez.
Thank you, Your Honor. I think the main issue right now is, of course, in the meantime, while we're waiting for someone to be appointed to administer the estate, there is a bit of a void left in this matter in terms of who is able to control and marshal the estate assets. And the primary issue that I want to bring to the court's attention today is pertaining to the decedent's residence, primary residence at 289 25th Street.
The judge explained that the court had received a petition to admit a will written in January 2025 into probate. Probate is the legal process used to validate a will and distribute a person's property after death. The judge also mentioned that there had been a recent filing in the case. It appeared that Ms. Chavez and her client had already submitted a response to the petition late in the previous week. The judge assumed that Ms. Schrader and her client might also want time to respond to that filing. Because of this, the judge invited both lawyers to share their thoughts about how to proceed. Ms. Schrader spoke first and said she wanted time to respond to the new filings. She believed that a longer hearing or even a trial might be necessary. She suggested placing the case on a trial-setting docket so that the issues could be argued properly before the court.
The primary issue here is that this is an estate asset. No one has been appointed to administer or control the house and manage the house. And since Mr. Reed has filed his petition to admit the 2025 will, he has taken multiple actions to control and ultimately damage this property. Primarily, he has removed all of the appliances from the home, including the sink. He's turned off the electricity, and I believe he's removed like the circuit board. And most recently, he has shut off the water, and there's no utilities running in the household right now. And it's basically uninhabitable, and it has greatly damaged unnecessarily the property. And this is not only detrimental to the estate, but it's going to cost the estate significant funds to repair this house and prepare it for whatever ultimately happens to disposition of the house. And so based on this, on these recent actions.
Ms. Chavez agreed with the suggestion made by Ms. Schrader. She stated that it would be fair to give the other side enough time to respond to the objections and legal arguments. The attorneys had already spoken earlier that day and discussed possible scheduling options. They believed that about 1 month would be a reasonable amount of time before setting the trial. This would allow both parties to prepare their arguments and gather the necessary information. The judge then asked for clarification about whether the month-long period referred to the trial itself or just the scheduling process. The lawyers explained that they wanted the case placed on the next available trial-setting docket first. After that, an official hearing date could be chosen about a month later. The court clerk helped by explaining that the universal trial-setting docket takes place every Wednesday at 9 a.m.
That are unauthorized by Mr. Christopher Reed. My client is requesting that he be ordered to return these appliances as soon as possible. We would request within 5 days of an order being issued that he return the appliances. And if he is the one personally returning the appliances, we would request that there be a civil assist involved with that, just to prevent any unnecessary issues between the parties. And also restore the electricity and the utilities to this property as soon as possible. And until we are able to find a suitable administrator for the estate, we would be requesting that he pay for these utilities himself, personally, financially responsible, because he was the one who took these detrimental actions in the first place and caused all of this harm to the estate property when he did not have the requisite authority to do so. So those are my primary requests for the court today.
I wanted to ask you, Ms. Chavez, you indicated that the removal of the appliances, the hot water heater, turning off electricity, turning off water, that
After reviewing the calendar, the judge proposed October 1st at 9 a.m. as the date for the trial-setting docket. Both lawyers agreed that this date worked for them. The judge confirmed that the meeting would take place on Zoom only. During that hearing, the court would decide how much time the trial would require and set a final date for the arguments. Once that matter was settled, the judge asked if there were other issues the parties wanted to discuss during the current hearing. Ms. Chavez confirmed that there were additional concerns that needed the court's attention immediately. The main issue involved the estate property belonging to the deceased individuals. Because no administrator had yet been officially appointed to manage the estate, there was confusion about who had authority over the property. This lack of control had created several problems regarding the management of the estate asset.
in turn caused damage to the property. Is the damage to the property just the removal of those items, or has there been damage due to, humidity or heat or something related to not having air conditioning or airflow or what have you?
My understanding is that included in the appliances that were removed, he removed the kitchen sink. So he cut out the kitchen sink from the kitchen countertop area, and there's a hole where the sink used to be. So that's going to require some pretty significant fixing up to put the sink back and to repair the countertops. In addition to, I believe that there is some sort of potential airflow damage to the house, but from what I understand, the primary issue was he cut out the sink and he removed the washer and dryer and the dishwasher and all of those things that are going to require replacement.
Okay. So your request is a return and reinstall the appliances, including the kitchen sink, and reattach plumbing and get the utilities turned back on and pay for those utilities.
Correct.
All right, thank you. Ms. Schrader?
Yes, Your Honor. My ultimate request is going to be for the court not to make a decision on those items today. My client does factually contest those allegations, and there's actually been some issues with my client returning to that property in 289 25th. There's been a series of civil anti-harassment orders between my client and other individuals residing at that residence. I don't believe that includes Corey Reed, but there are a number of other members of the Reed family who are residing there. My client, Christopher Reed, actually has a background in construction, and any removal of items of the property that were done previously, he's been excluded for the last at least 10 days. But anything that was removed prior to that, my client has maintained either he purchased or he was looking at repairing that property. He's invested significant time and resources in repairing this property. The issue obviously being is that there's a number.
Ms. Chavez explained that the most serious issue involved the deceased person's main residence, located on 25th Street. According to her statement, the property is part of the estate and therefore should be protected until the probate process is completed. However, she accused Christopher Reed of taking several actions that harmed the property. She claimed that he removed many appliances from the house, including the kitchen sink. In addition, the electricity had been turned off and the circuit board had been removed. The water supply had also been shut off, leaving the house without utilities. Because of these actions, the house had become uninhabitable. She argued that these actions caused unnecessary damage and would cost the estate a significant amount of money to repair. As a result, she requested that the court order Christopher Reed to return the appliances within 5 days and restore the utilities immediately.
Individuals residing there unauthorized who do continue to damage it. And my understanding is that there has been a large number of problems with bringing generators into the living room. There's chemicals leaking all over the floors. So as far as my client's position goes, he maintains that anything that was removed was his own property that he purchased at his own expense, or it was removed in order to update and repair those items. But at this point, there's a civil anti-harassment order preventing him from even returning to the property. So partly my reason for requesting the court not order my client to pay for water and electricity to this residence is, at this point, I don't even think he's allowed to go to the residence. Not until that civil anti-harassment order is dealt with. It's currently temporary. Looks like there was no service, but the next hearing for that order is October 8th. So like I said, Your Honor, my client's not able to return to this property. It's not in his name. He has resided there in the past, as have a number of members of the Reed family. So at this point, I don't think it would be appropriate to order one specific family member to pay for these items. It's just an unfortunate situation where we have a large number of individuals who are essentially squatting at this point. And it's difficult to say who should be responsible for the electricity and the water other than individuals actually residing in the home. So I don't think we have enough information at this point to say that one individual should be responsible for paying all of those items. Again, my client does contest damaging the property in any way. And in fact, we do plan to submit a declaration and additional documentation about the steps that Christopher Reed has taken to improve this property and make sure that everything is flowing appropriately. But at this point, if he's not able to return, he doesn't know who's residing there or what they are doing or what they're not doing. My client would not be inclined to pay for water or sewage for this property. So Again, I think we just need a little bit more information from both sides before the court orders any particular person to take action with respect to the property. I am going to confer with Ms. Chavez. We're going to propose a number of individuals to try to come up with a personal representative for the estates. That will be, once we have a personal representative to work with on these issues, I think it will make it a lot easier to work out any of the other remaining items related to appliances, and then other bills related to the property. But I just don't think we have enough information for the court today, to rule on those items. So my position would be that we address them at a later date.
Thank you. Can I ask you a question? Who's living at the home?
I believe Daryl Reed, Daryl Reed's daughter, Chelsea Busanich. Daryl Reed has, I think Tanya Riley is a significant other of his. She's identified 289 25th as her primary residence.
The judge asked Ms. Chavez to explain the type of damage that had occurred in the house. She clarified that the removal of the kitchen sink had left a large hole in the countertop. This meant that the kitchen would need major repairs before it could be used again. Other appliances such as the washer, dryer, and dishwasher had also been removed. Replacing or reinstalling these items would require additional expenses. She also mentioned possible airflow and environmental damage due to the lack of electricity and utilities. Without proper ventilation or climate control, the condition of the house could worsen over time. Because the property is an important asset of the estate, she believed these actions were irresponsible. Her request was that Christopher Reed should return and reinstall all the removed appliances, repair the damage, and restore the utilities to the home.
And there's a couple of other individuals who are affiliated with Daryl, Chelsea Busanich, and Tanya Riley, who reside at 289 25th regularly. I don't have an exact number of who all is residing there, but it sounds like there are multiple individuals who come and go, with those three primarily being the ones who are staying there. But my client has not returned there since the anti-harassment order was filed by Tanya Riley, and he became aware of that on September 10th. So my client's not returned to that property since September 10th.
Thanks. Ms. Chavez, what is the cost to restore electricity and water? Do you know, is there a hookup fee?
I don't know what the fees are. It's my understanding that my client has not had much transparency into how much money has gone into the utility payments or what exactly the cost of repairing those are. But it's my understanding that the utilities were in Mr. Christopher Reed's name prior to the decedent passing away. So we don't have any insight into how much those utility payments are, how much it would be to restore those.
Christopher Reed's lawyer strongly disagreed with these accusations. She told the court that her client disputes the claims that he damaged the property. According to her explanation, Christopher Reed had actually invested time and money into repairing the house. She said that some items removed from the house were purchased by him personally. Other items were removed temporarily because he planned to repair or replace them. She also explained that there are currently several people living in the house who may not have permission to be there. These individuals could also be responsible for some of the damage. In addition, Christopher Reed is currently unable to return to the property because of a temporary civil anti-harassment order. This legal order prevents him from entering the residence until another hearing takes place. Because of this situation, she argued that it would be unfair to require him to pay for utilities or repairs.
Or the individuals that are living at the home, could they restore the service?
I don't believe so. I think the circuit board has been removed, and I believe that the water heater has been locked by Mr. Christopher Reed, so he has prevented anyone from accessing these or from fixing them.
So the electrical panel has been removed from the home?
That is my understanding.
And that was different than the information I had. I can certainly address this issue with my client. I wasn't even sure how that was possible.
Christopher Reed nodding his head in agreement that the electrical panel has been removed. So I'm assuming with his nod of the head, that's an accurate indication.
And that is Corey Reed nodding his head, Your Honor. My client, he has been at the property somewhat recently, and he has photos that this has been removed.
Okay, so that's Mr. Corey Reed that was nodding his head here. Okay,
Correct, yes.
thanks for that correction. I appreciate that. Well, I guess Ms. Schrader, if your client's concerned about damage to the home or chemicals with the generator being present, there's a pretty easy way to resolve that and then have electricity to the home, because if the home is going to be an asset of the estate, it's either going to waste away and not be used, or it's going to be sold at some future time. And if it's going to be sold or utilized or transferred to another party, it's going to need electricity, it's going to need an electrical panel, it's going to need a water heater, it's going to need appliances. Does your client, Ms. Schrader, does he have receipts showing that he bought the water?
Christopher Reed's lawyer continued explaining that her client has no control over the property right now. Several members of the Reed family are reportedly living in the house, including Daryl Reed and his daughter Chelsea. Another individual named Tanya Riley is also believed to live there. Because multiple people are using the property, it would be difficult to decide who should be responsible for paying the bills. Her client also argued that if he spends his own money on the property, he should later be reimbursed by the estate. She requested additional time to gather documents and receipts that prove which appliances were purchased by Christopher Reed. She also wanted time to present more evidence about the improvements he made to the property. According to her argument, the court did not yet have enough information to make a fair decision about responsibility for the property.
Heater, dates and the like, and how am I to understand that that's his property as opposed to the gift to the home? Because it sounds like, from what I read in the pleadings, which is pretty voluminous, is that he was making plans to purchase the home or move into the home, and so it sounds like he just doesn't want to have anybody use any of those items or use the home in any fashion, so he's blocking them.
And my client would disagree with that position. I don't have currently all of the receipts for the items that he did purchase. I'm sure he can obtain those. And again, I was not aware that the electrical board was removed or that the water heater was locked. I can certainly address those issues with my client. I think his position, it's not as if he shut off the services to this property purposely. It's just that he wasn't able to access it, so he just stopped paying the bill since he wasn't living there and he didn't know who was living there. Understanding this is an estate asset, and we certainly want to protect it to the extent we can. It's just my client wants to make sure that he's compensated for anything that he does pay for this home, as it is an estate asset. He'd be using his own personal funds to pay for services to a property that he's not even able to return to at this point. So he would certainly reserve a claim against the estate for anything that he does pay for in terms of services for the home. I will absolutely address the electrical board issue. When I spoke to him previously, he didn't indicate that anything had been locked. And again, there is that issue of, we have several individuals residing in the home. We don't know who has keys to what. My client may not have actually locked that water heater. So if he didn't lock it, then we're in the same position. I don't know how we get in. I do think there's a lot more that my client would like to add in response to Corey Reed's objection. And he certainly has a very different perspective factually of what has happened with respect to the 25th Avenue address.
Corey Reed's lawyer gave a final statement emphasizing the importance of protecting the estate property. She explained that her client cannot control who currently lives in the house. However, the property still belongs to the estate and must be preserved until the legal process is finished. She argued that Christopher Reed had acted as if he personally owned the property, even though he did not have legal authority to control it. Removing appliances and shutting off utilities caused damage and increased the cost of repairs. These actions could reduce the value of the estate and harm all beneficiaries involved in the case. She asked the court to require Christopher Reed to fix the damage immediately so that the property would not deteriorate further while the probate case continues.
And what's going on with it now? So he would just like a little bit more time to respond, provide any receipts for appliances so that we can get that information before the court. And it doesn't sound like we have a firm idea of what it's going to cost to get services back on in this home. I would just be hesitant to order my client. Or I would be concerned if the court ordered my client to pay bills that we don't know how much they are, how much that is going to financially burden him. And again, for a property that he's not able to return to at this point, and he hasn't been to in almost 2 weeks. So I think we need a little bit more information to figure out if he is going to be ordered to pay for that, how much is that going to cost? He would certainly reserve a claim that he should be compensated from the estate assets for anything that he does put forth of his own personal funds. But at this time, I would still ask the court to refrain from ordering my client to take any specific actions until we have a little bit more information about what he did pay for, what he has not paid for, and then how much these bills have cost in the past and how much we expect them to cost in the future. I would just submit that it would not be fair to ask my client to pay electric bills or for costs with individuals residing in the home that may or may not be inclined to write up the bills if my client's paying for them. There's just a lot of animosity among family members, so that would be a concern I have as well, Your Honor.
Thanks. Ms. Chavez, final comments?
Your Honor, I think just the basis of our request and Mr. Corey Reed, my client, we can't speak on behalf of any of the individuals who are residing in the property currently, and he certainly does not condone people living in that house when they are not supposed to. He can't speak to their positions. But I think the main thing that we're concerned with is that this house is an asset of the estate, and Mr. Reed has been acting as though he personally owns this property, and he has been exercising control to essentially damage this property and create a lot of issues for the estate, including rising the cost of funds that it's going to take from the estate to repair this estate asset that he had no business messing with. And he just did not have the legal authority to go in and remove these appliances, whether or not they were alleged gifts or when these appliances were purchased. I think it's pretty clear from the record in this case that those were not gifts provided by Mr. Christopher Reed and that they were in this house for a very long time. And he damaged those things. And so he needs to make the estate whole. And this needs to occur sooner rather than later, because as the estate administration gets into gear, this is just going to become an even larger problem, and it's going to snowball out of control if we don't address it right now. And those are my final thoughts, Your Honor. Thank you.
Thanks. Okay, the thing that stands out in my mind is that this is an asset that needs to be preserved for the estate. And we're moving into the colder months at this point in time. There's also having people live within the home is a protective factor of that estate asset. If there's a vacant home, people catch wind of that, there's potential danger. It's at a greater risk if it's non-inhabited versus if it's inhabited. People will generally steer away from home and not squat. I know that there's allegations of squatting here, but so that's the first thing that pops to my mind, is that there's a need to preserve the estate asset. My thought with the electricity is that the electricity and the water need to be reestablished. And this is the party that's going to bear that cost. I think it's the party that's going to be using that. So I think Mr. Christopher Reed, if there's any outstanding bills due for water and electrical that prevent a rehookup, he's required to pay those outstanding bills. That will allow the residents that are there, which is been portrayed as Daryl and Chelsea and Tanya, that they, on an ongoing basis, once they've restored service and any hookup fees, they would be responsible for those, and they would be responsible for any bills of moving forward. Then, as far as the return of the electrical panel that has to be reinstalled, Mr. Christopher Reed will be responsible for paying for that out of his pocket. Certainly that issue is reserved for reimbursable costs from the estate, but that issue will be reserved. And then the water heater needs to be operable. Water and electricity need to be operable so the home is habitable, sorry. And then This all needs to happen within 7 days of today's date. So there will need to be a civil standby that Mr. Christopher Reed will have to coordinate with law enforcement so that they're present and allow him to be there at the house to reinstall the electrical panel or have another do so, and also to return or turn on or unlock the water heater, and the appliances need to be returned also. They can be figured out who owns them or how they came to be at the house at a later date, but the home needs to be in a habitable fashion, and that, I think, aids in preserving the well-being of the estate asset. So that'll be the court order. Ms. Chavez, if you could draft that and present it to the court and send it to Ms. Schrader. If Ms. Schrader agrees, it could be forwarded. If not, then we would need to set up for a presentation docket for possibly probably the Friday following this Friday, which would be the 3rd of October, 8:45. So we'll set that as a backstop of October, Friday, the 3rd at 8:45 for presentation of the order that was provided today. And I'll entertain any questions or clarifications related to the order. And if there's none, then we can call it good, and then we'll see everybody on October 1st at 9 a.m. for the trial assignment. And if needs be, presentation on the 3rd of October at 8:45.
Just one point of clarification, Your Honor. You stated 7 days of today's date. Is that correct?
Yes, ma'am.
Thank you.
Okay.
Nothing further from me.
Nothing further from me, Your Honor.
Very good. Thanks very much.
Thank you.
After listening to both sides, the judge announced the court's decision. The judge stated that the main priority is to protect the estate property. The house must remain in good condition so it can be used or sold in the future. Therefore, electricity and water must be restored so the house becomes habitable again. The judge ordered Christopher Reed to pay any outstanding bills that prevent the utilities from being restored. The residents currently living in the home would be responsible for future utility payments. Christopher Reed was also ordered to reinstall the electrical panel and ensure that the water heater works properly. All appliances must be returned to the house. These actions must be completed within 7 days, and law enforcement must be present during the process to avoid conflict. The judge concluded the hearing and confirmed that the next court date would be October 1st.